Thank you very much for that kind introduction, and thanks for having me. It's nice to be here. I'm particularly, I think, excited to be here because of what I assume is this crowd, a nice public policy crowd, which I don't normally speak to, and I thought I would try to craft a slightly more public policy-ish address, which is right up my alley because I want to talk about the Brooks and Brewer cases, but I want to talk about them in ways that I don't normally get to talk about them. So let me start. I'm going to, we'll have some time at the end for questions because I have a feeling that some of the, at least the subject matter area that I want to stick to, I'm going to gloss over some particular areas about precisely what it is we do, how we pick our cases, questions I was asked over lunch, which you're welcome to ask. But I am going to sort of skip over some things to get to what I think is important about these cases and is not talked about as often as it should. The mission of our project is similar to missions of innocence projects across the country, which I assume everybody is, or most people anyway, are relatively familiar with, and that is, as you've mentioned, we are searching in Mississippi for viable cases of innocence, for people who write to us, send us an application, who we think have meritorious claims of innocence, who are serving lengthy periods of incarceration. And by and large, as a practical matter, that means homicide cases and sex offense cases and some drug cases. Mississippi likes to lock up people at significant high percentage rates. I think other than Louisiana, we lock up more people per capita than any other state in the country. That includes drug cases. As a consequence of the last roughly decade and a half of innocence work around the country, and you guys, you see this, you saw it in the West Memphis case, but you see this almost weekly, these stories about people being exonerated, oftentimes through post-conviction DNA testing. But we're somewhere up, when I say we, I mean, the national innocence movement, as it were, is up to about 300 and some post-conviction DNA exonerations in the last 15 years or so. That does not include non-DNA exonerations, which there's a professor at Northwestern who keeps sort of a rough track, and I think there have probably been about 12 or 1,500 of those in the last 30 years or so. So it's not an uncommon occurrence anymore, and it tends these days to get news coverage in ways perhaps that it hasn't in the past. As a result of these developments, there have been sort of nationally policy measures put in place in many states and at the federal government level. And just to give you a couple, in Mississippi, for example, a not uncommon situation, we had a couple of exonerations, actually the Brooks and Brewer cases. Shortly thereafter, we were able to have the Mississippi legislature pass and Governor Barber sign into law DNA, post-conviction DNA testing statute and DNA retention statute, something that didn't exist. And then that has occurred in almost every state in the country, and as I said, in the federal government. One of the, as it turns out, one of the problems that we've come to find out is closely associated with wrongful convictions is eyewitness misidentification. Who would have thought? Who would have thought, right? Because you watch these crime shows, and any of you who've ever either served on a jury or been in a courtroom or, God forbid, been the victim of a crime, these moments in court when the prosecutor says, do you see the person who raped, robbed, assaulted you, whatever it is, and there's, it happens in every case, and it's a dramatic moment, and the victim turns to, if you're like me, a public defender, turns to your client. They do it every single time, and they say, there he is. I'll never forget his face. It's a very dramatic moment for jurors. It's not worth anything from an evidentiary standpoint because, in this country, it's usually the black guy sitting at the counsel table. It's easy to pick. But it nonetheless is a dramatic moment. Well, it turns out that Far more often than we would have thought, eyewitness identification can be flawed. Not every time, by any stretch, not every time by any stretch, but in cases where you would be absolutely positive that the victim got the right person, is identifying the right person, turns out they're wrong. And there's some interesting sort of sociological, psychological, empirical data about why that happens, which we now know about, and which many states and the federal government have seen fit to do something about. And we're trying to pull the Supreme Court kicking and screaming along with us. But we've instituted eyewitness ID reforms, which I like to say are beneficial to everybody, not just my client, but to the victim, and to the victim's family, and to the community at large, because you can be better assured that the person that the victim is pointing to is actually the person that committed the crime. False confessions. Also, who would have thought? Who would have thought? You guys had your own incident here where I grew up in Richmond, Virginia, just down the way in Norfolk. There's an infamous case where people confessed to the most horrific criminal offenses imaginable, and then got up on the witness stand and testified against their co-defendants. And it turns out that they weren't involved, that they had falsely confessed. And there's a sort of slate of legislation in various states to tape these confessions and to do things that will cut down on the incidence of false confessions. But that, as I said, is not really why I'm here to talk to you today. If you want to ask me questions later about those things, fine. But I want to move on to something else. And I want to talk about, at least I have it in my notes, as the hidden public policy implications. Those things that don't get talked about. Because eyewitness ID reform, taping confessions and so forth, DNA post-conviction statutes, that stuff gets talked about. And I want to talk to you about this subject by talking about these two cases that you mentioned in your introduction, the LaVon Brooks and Kennedy Brewer cases. Let me tell you a little bit about them. In the fall of 1990, right around preseason NFL football time, because there was a preseason football game on the television when this offense happened. A little girl, Courtney Smith, went to bed with her sisters. She was 3, and she had a younger sister and an older sister on either side of her. Her older sister, I think, was 4 or 5. The younger sister was an infant. In a little house in a little town in Noxubee, Mississippi. The town is Brooksville. Noxubee, and I'm going to get to in a minute, but it is in the east central part of the state. Its eastern border is the Alabama state line. It is, in my opinion anyway, it is as isolated a part of Mississippi as you can find. It is not unlike the Mississippi Delta on the other side of the state, your side of the state, this side, in its isolation. It's also not unlike the Mississippi Delta because it's part of the Black Prairie Belt, which is a swath of black, loamy, rich soil that stretches from upper Tennessee, north of the border, down and sort of like a crescent. And Noxubee County has the largest concentration of black prairie anywhere. And that's important later when I describe to you what Noxubee County's like. But it took place in a little town in Noxubee. She went to bed, and the next morning, her family woke up and she was gone. And that was not uncommon. She was a little tyke, and she would get up, and it was a little African-American community where everybody knew each other, and she would run, people would run up and down the little dirt lanes and visit neighbors, and that's where they thought she had gone. And the family sent her older sister out to try to find her, ran down to her grandmother's house, couldn't find her, looked for her the better part of the day. Her mother was not there. Her mother had gone out, and there was some thought that her mom had her. And so when her mom came back that night at about 7 without her, people panicked, and they called the police, and the police came immediately. The neighborhood got together, and they started searching for her, and they searched for her all night. They couldn't find her. The next morning, The chief of police of this little town got up. He had spent the night there in his car. He's a good guy. And he walked up to this little pond right around the corner, and her body was floating in the pond. They ended up arresting LaVon Brooks. He had had connections with the victim's mother, used to date her. But the reason they arrested him was because the older sister in the bed, purportedly anyway, identified him as having been the person that came and took her sister. She was, as I say, 4, almost 5, and so her identification had its issues. But what sealed the deal was that the little girl, Courtney Smith, the victim, had a bunch of bite marks on her body. And the state called in a forensic odontologist, a dentist, and he took molds of Mr. Brooks's teeth and he matched them to the marks on the little girl. And in his words, they were indeed and without doubt caused by Mr. Brooks. The state of Mississippi indicted him for capital murder and announced that they were going to seek the death penalty, and he went to trial, got convicted, but did not get sentenced to death, got a life sentence instead. About a year and a half later, about 6 miles as the crow flies from where Courtney Smith was abducted, another little girl was abducted in the middle of the night from her bed. No eyewitnesses. She, like Courtney, was manually strangled and sexually assaulted and dumped in a body of water. Same thing happened. The state law enforcement found the body, sent it to the same pathologist who thought that he saw bite marks. He then referred in this forensic odontologist who said, sure enough, they're bite marks. They took bite mark molds from their main suspect, Kennedy Brewer, he was not the father of the victim, but he was her sort of, her mother was they were boyfriend and girlfriend, and they had a child together, but this child wasn't his. But he was the main suspect. He the last male alone with the victim. And indeed and without doubt, said the forensic odontologist, the bite marks on this victim matched Mr. Brewer. He too was indicted. Same prosecutor sought the death penalty. They tried the case in a different county, not Noxubee, and Mr. Brewer was sentenced to death. The law enforcement was, take my word for it, derelict in both cases. It's terribly done. Because you know what happened, the forensic odontologist is a fraud. Always has been, always will be. Same for the pathologist, a fraud. The defense lawyering in the case was so substandard that it's just shocking. I teach a class as part of the clinic, and yesterday we did mock opening statements in Mr. Brooks's case. Students, I give them the discovery, and we talk about how to do opening statements, and they get up and they do an opening statement. And one of the reasons I have them do it, obviously, is to get on their feet, but the other reason I have them do it is to contrast their opening statement to the opening statement that Mr. Brooks's attorneys gave. When the state got up to give its opening statement in Mr. Brooks's case, it was only, if you look at the transcript, it's less than a page long. The prosecutor just got up and he said, ladies and gentlemen, the state of Mississippi is going to show that on early September 1990, Courtney Smith was abducted from her house. She was sexually assaulted, thrown in a body of water, manually strangled, and the person that did it left his mark. And he walked over to counsel table and pointed to Mr. Brooks, and he said the state of Mississippi is simply going to show that the bite marks on her body belong to Mr. Brooks. And he sat down. As I tell my students, imagine, you take yourself back to 1990 and imagine what that courtroom was like at that moment. And this is one of the challenges, but one of the fun parts of being a fun's not the right word, but you get what I'm saying, of being a criminal defense attorney. Because everybody looks at you and thinks, what in the world are you going to say? And that's your job. And these students did a terrific job yesterday for first-timers. But in Lavon's case, when the judge turned to his counsel and said, it's your turn to make an opening statement, they waived their opening statement. That will give you the flavor of the level of representation that he got in that case. In 2008, as a result of DNA testing in Mr. Brewer's case, we were able to determine that Mr. Brewer was in fact not the source of the semen that was taken from the victim in that case. Unfortunately, the DNA in Mr. Brooks's case was so degraded that we couldn't test it. But it doesn't take a genius, does it, to think that in Noxubee County, 2 child abductions with uncannily similar MOs, that it's quite possible that it was the same perpetrator. We asked the local authorities about that, and they said, no, we didn't think that was the case because we had already locked up Mr. Brooks. But we tried to test the DNA in Mr. Brooks's case, and it was too degraded. But, long story short, law enforcement had done cheek swabs. They had arrested a whole bunch of suspects. Evidently, there's like a cone over Noxubee County where the Fourth Amendment does not apply. And they had swept up all these folks. And some of the cheek swabs they took were still around, and we tested them from Mr. Brooks's case, and it was an exact match to the semen that was taken from the Brewer case. That person, Justin Albert Johnson, was a serial sex offender. People knew that in the county. He was a suspect in both cases. He ultimately did time at Parchman for a sex offense in the county. But he was out in 2008, and once we got the DNA results back, we did not go to Noxubee County law enforcement. We went to the Attorney General, who sent some of his folks down, knocked on Mr. Johnson's door, and he came to it. They arrested him, and he admitted to both cases. The media reaction to these exonerations was, in many respects, what you would expect, what we talked about a little bit back in the back, which was that there was a New York Times article about it, and as the New York Times is wont to do, it sniffs at the South sometimes, and did so in this case, in particular, Noxubee County. And Noxubee County, deservedly so, has a big target on its chest. Fair enough. But the press release that came from the Innocence Project in New York, who did most of the work on the cases, had the same flavor, which was that this was an artifact, if you will, from the 50s and the 60s. This is something that we thought was something of the past, but yet it lives on in these types of cases. But what I think is interesting, is I've spent a lot of time, I was counsel in the cases, and then I've gotten to be friends with both exonerees, and I've been in Noxubee County a lot, and this is what I want to talk about in the main, is that that's not the case. That's not at all what happened. It's not at all what happened. I can understand why people would say that, because to get back to Noxubee County now and the Black Prairie Belt, which I think is interesting and most people don't, so I won't spend much time on it, but it's an interesting place. It has this soil I was telling you about. And beginning in about the 1830s, once the Indians, Native Americans had been removed, it was quickly settled. And just like the Delta, it was you could plant cotton, and it was unbelievable. There was money, massive amounts of money to be made. And as a result, Noxubee imported slaves at a faster clip than any other county in Mississippi. And by the 1860s, by the start of the Civil War, I don't remember precisely what the percentages were, but Noxubee, among counties in the Black Belt, for sure, and relative to the Delta, which was a little bit later in developing, had the highest percentage of slaves to white landowners of any county in Mississippi and almost of any county in the South. After the Civil War, Ku Klux Klan, in part to protect the economic interest of white planters, was a presence in Noxubee County. I found letters. Some of you all might be familiar with the Southern Tenant Farmers Union, which started in the Arkansas Delta. Someone had a death wish, evidently, starting a union in the Arkansas Delta in the early part of the 1900s. They were starting these unions, and a lot of them attracted African American farmers who were then freedmen. And there are letters in the archives of the Southern Tenant Farmers Union from Noxubee County. There was a couple unions there. The subject matter of these letters is not union matters. They're these cries for help. They are heartrending. Please come and help us. Last week, a friend of mine tried to court a white girl, and some guys got him in Brooksville, the same place where LaVon Brooks's case happened, and they cut his testicles off. Please come help us. I mean, there's letter after letter like this. Noxubee County was as deep and as dark of a region as there was in Mississippi, from prior to the Civil War on through into the early 20th century. In about the 1940s and 50s, as the civil rights movement nationally gained steam, Noxubee County battened down the hatches. There was a guy named Boswell Stevens, who ultimately became the president of the Farmers Union. He controlled millions of dollars of farm subsidies that were sent from D.C. to, among other places, Mississippi, to give to farmers. He doled it out according to a status quo that was going to keep black folks in particular in their place. He lived on a plantation in Noxubee County. That was where he was from. There were no registered African American voters in Noxubee County until the early 1970s. The Citizens Council and the Mississippi Sovereignty Commission, you can get on all those records have now been made public, and you can go and you can look up and you can read these reports from Noxubee. The place was locked down tight. It was, as I say, as bad a place as you could find. Interestingly, in a connection to this case, the name Brooks and the name Brewer appear on the earliest slave rolls from Noxubee County. There's no, unfortunately, the sort of family history stuff has been lost, so I can't say with any certainty that this is the same family, but I'd be willing to bet that there is a connection. They go way back. Kennedy Brewer's mother, who's a terrific woman, she's in the documentary you mentioned, she says that when I asked her about sort of her life and what she's done, she says she chopped cotton. And I asked her naively, when did you start doing that? And she said, as soon as I could. Kennedy Brewer, that is as connected to Noxubee County and those layers of history as anybody. So is LaVon Brooks. Because, as it turns out, LaVon Brooks, the foreperson of LaVon Brooks's jury, was Boswell Stevens' grandson, Boz Stevens. And I went to talk to him, and he said, yeah, he's a terrific guy. And he said, yeah, I was surprised to be on that jury. And I said, why is that? And he said, because I know LaVon. I was like, well, I guess in a county that small, you'd know LaVon. He goes, no. He was born on a tenant cabin on the plantation. That case was as Noxubee County as it gets. But here's the thing, and this is what I think is so interesting. About 6 or 7 years ago, the United States government, through the Department of Justice, brought a Voting Rights Act case in Noxubee, to which I think most of you would say, well, it's about time. It's about 100 years too late, but it's about time. Interestingly enough, however, the case by the DOJ was against black folks for keeping white folks away from the polls. African Americans have dominated Noxubee County elections since roughly the mid-1980s. There is a state representative, African American woman, absolutely terrific, courageous, brave woman who was first on the school board and is now a longtime member of the State House of Representatives, which, by the way, is in keeping with the rest of Mississippi, which has the highest percentage of black representatives in the legislature than any other state in the country. The jurors, both grand and pettit jurors, for Mr. Brooks's case and Mr. Brewer's case, were blacks and whites. Who would have thought? Who would have thought in 1959, if you had gone to that tenant cabin in the the eastern part of Noxubee County on this plantation and been there when LaVon Brooks was born, if you had said, I predict he's going to be in trouble with the American criminal justice system, everybody would have nodded their heads about that. But if you had said that he's going to go to a trial where he got indicted by a grand jury that included black folks and white folks, that he was going to be tried by a pettit jury that had black folks and white folks, that no one was going to utter the word nigger, or there would not be any race-based bigotry in its trial, I think in 1959 that would have been hard to believe, that day would have come to what we know is Noxubee County's history. But it did. But it did. And as you all know, the journey, particularly for black folks, to get on that grand jury and to get on that pettit jury is a story of courage. Many of them, especially the older folks, risked their lives to do that. There was a woman, Sadie Guyton, on the jury who was 90. She graduated from high school, in college, and had a master's in education. That's something else. That's something else from Noxubee County. And as I mentioned, Boz Stevens was on there too. And he's a great guy. And I asked him about the trial and about his thoughts and about growing up. And he is, he's admittedly not the guy who's going to be, a flag waving at the next sort of Million Man March or civil rights demonstration. I mean, that's not his MO. But he's a good guy. And he took a journey also. And when asked about it, he just says, look, I'm not my grandfather. And my grandfather wasn't me. And arguably, that journey, although of a different type, is every bit as courageous as the one that Ms. Guyton herself took. And they were there. They showed up. But after all that, after those sacrifices that they made and that others made to have a trial like that, what they ended up participating in, I would argue, is a legalized lynching. And that's what happened. And lynching is probably not the right word, because to the extent that lynching means that it's a sort of out-of-court administration of punishment, this was not that. This was in some ways worse, because this took place inside of a courtroom that gave every indication of being something that we aspired to: black and white participation, deracinated trial. And yet what happened to those two guys, and what would have happened for sure to Kennedy Brewer had we not come along and asked for DNA testing and pressed in the case, is that he would have been executed. It was, in the sense I used the word then, a lynching, but worse. It was a lynching that had the blessing of the Noxubee County Circuit Court, the Mississippi Supreme Court, which affirmed both cases, and the United States Supreme Court, which denied certiorari to Mr. Brewer's case. I think in the end, and what I want to impress upon you today is, yes, eyewitness identification reform is important. So are taping confessions and passing legislation that will allow us to do more DNA testing. But to my mind, and obviously in Mississippi, given its history, this has a certain resonance that may not exist in quite the same way in other parts of the country. But what is also as important are these public policy ramifications that flow from cases like this. Because it's not just about Mr. Brooks and Mr. Brewer, although that's plenty. And it's not just about the two little victims in this case, although goodness knows that's plenty. And it's not just about their families or the communities in Noxubee who watched two innocent folks get locked up, but it's about us. It's about us. It's about the way we believe, oftentimes, our criminal justice system works, and the way, I would argue, the way it perverts what we all either say we stand for or what many of us have actually made pains to stand for, like Boz Stevens and Sadie Guyton. And to have them sold out, traduced, to have their efforts backfire on them in that way, I think is as tragic as the wrongful convictions that happened in either case. Thanks for bearing with me about my Black Prairie fascination. But I do think it's a really interesting story. We had mentioned in the back about sort of media attention to these cases. The cases are interesting. You know, when someone gets freed from death row, as you might imagine, the media attention is on that. That's a big deal, as it should be. But I do think, as I say, that there are other things that are as resonant, that take a little bit of time for us to look into beyond just the immediate aftermath of an exoneration. Thanks again for having me, and I'll be glad to take any questions that people have.
Thank you, Tucker. All right, we have time. There's a question right there. Wait for the microphone, please.
When you receive an application, what are the items that you look at to determine if you'll follow this case?
When we get an application, there are, the way I generally describe it is, there are hallmarks that we look for when we screen cases. Remember when I first started talking, I was talking about eyewitness identification, false confessions, those types of things. The application that we send to people is about 30 pages long, and among other questions we ask are, was this a stranger-on-stranger assault, for example? Was the victim or the witness who provided testimony against you a stranger? Was that the only witness that there was? Is there untested DNA in the case? Or if there was DNA testing, when was it done? Because obviously the advance in technology may mean that a test that was done, say, in 1990 might be redone now. So there are several items, if you will, that or hallmarks that we look for as an introductory matter that would begin to define for us whether we think this is a case that we can, is either A, viable, or B, that we can do something with. And those are two different considerations. We have a lot of viable cases in our office, but they're not cases that we can do anything with. The evidence is missing. Witnesses have died. Things like that, right? That you're at a dead end, even though you think that the case may in a different situation have yielded some result.
My name is Fernando Coots. I'm a student here at the Clinton School. Thank you very much for coming. Based on your experiences, I guess based on the data you've seen and the people you've talked to, what would be your best guess, whether in Mississippi or nationwide, as to the percentage of people on death row that you think are either innocent or at least questionable whether or not they are guilty?
I appreciate your question, but then now I'm going to make fun of it. That's always, but it's a good question. But it's sort of like the $64,000 question. And this is where the old public defender in me comes out. I don't know. I have no idea. I hesitate to hazard a guess because I just don't know how much it advances the ball, really. You know, I mean, there's professors smarter than I am who have done, like, you know, empirical I don't even know, right? And they come up with anywhere from 2 to 12% of the incarcerated population having claims of innocence. But to my mind, and I mean this with all due respect, it's almost irrelevant. Because what we know is that we can do better, right, with eyewitness identification. Or with, goodness knows, you can at least stand up and give an opening statement in a death penalty case, regardless of level of culpability. It was one thing I say to people sometimes, and I will now, since you asked the terrific question, is, hey, what if, you know the story I told you about LaVon Brooks' attorneys who couldn't be bothered to stand up? Let's just say that LaVon Brooks was guilty. Let's just say that he had indeed abducted that little girl and taken her out and done that to her. The sin, the lack of professionalism by the attorneys is no better because he's culpable. Arguably, it's worse. And so while I understand your question, I think it's a good one, and people ask, they want to know, I think at some level, right, it misses the larger point, which is these things, these systemic problems that locked up innocent folks, well, they happen to the guilty alike, and they're no better.
I'm Mike Dabney. I'm from Mark Tree, and I drive in for these because I like them so much. I appreciate you being here. My dad graduated from Ole Miss Law School. Was there ever a strategic basis that you learned that the defense attorney did not, that he waived opening? Did he later give an opening before his case started?
He did later give an opening. You know, in litigation, you can give an opening at the end of the opposing party's opening, usually the beginning of the case, or you can wait, and in a criminal case, you can give it at the beginning of your case in chief after the after the prosecution rests. There were two of them, he did give an opening statement. It was, you'll just have to trust me, I don't have the transcript, but it was arguably worse than not giving a opening statement. The first line was something like, ladies and gentlemen, we're here today because of the death of Courtney Smith blamed on my client. Like, you've been there for a week and a half. Like, if there's a juror who's unsure why they're there, then there are larger issues at stake. But the other thing was, it was the case went to trial in January, and there must have been I was not there. I haven't gone to law school yet. But there was a heater on in the courtroom, and the judge had to tell him to speak up so that the jury could hear him over the heater. So not only was he not particularly effective from a rhetorical point of view, he also evidently wasn't particularly effective because no one could hear what he was saying. But anyway, no, there was not.
Right here.
Imagine that.
Don, right over here, yeah.
Thank you. I have a two-part question. One, I assume ineffective assistance of counsel was raised on the appeals. And secondly, what's your general opinion of appellate courts today in the United States dealing with ineffective assistance of counsel claims?
Great questions, both. Here's the thing. In Mr. Brooks's case, he was granted the right to direct appeal. It's part of your Gideon guarantee, right? You get a direct appeal to the Mississippi Supreme Court. And one of the things that you might like to have raised was an ineffective assistance of counsel claim. Is everyone with me? No, your lawyer didn't represent you to constitutional sort of levels, and you should get relief from that. That's what that claim's about. Well, the court appointed him a lawyer, as it should have done. It was his trial lawyer. So the likelihood of his lawyer raising an ineffective assistance claim against himself was low. Now that said, That said, I will also, you know, and you, I suppose you need to take this with a grain of salt, but I think I'm being as objective as I can be in answering the second part of your question, which is the guiding case for ineffective assistance of counsel is Strickland versus Washington. That was Mike's question about whether there was some tactical decision that the lawyer would have made not to make an opening statement. Strickland v. Washington is virtually useless in my estimation because the rubric under which it judges ineffective assistance of counsel hardly ever gets at the heart of what is wrong in the kinds of cases that should be addressed, if that makes any sense. In other words, because it's, look, most courts would have said in Lavon's case, even if the lawyer had failed to make the opening statement, and even if that decision fell below constitutional standards, given the evidence against him, it wouldn't have made any difference. That's the second part of the Strickland test. I know I'm in a small minority, but I will cop to it right now. That's outrageous. It may be true that it wouldn't have made a difference, but sort of along the lines of what I was trying to explain to you in my talk, it's just fundamentally, patently outrageous to line up to kill a guy and give him a lawyer like that. It's offensive. It's offensive to me, from a professional point of view as a lawyer. I mean, that person brings shame, I think, on lawyers generally and certainly on the defense bar. But it should also be, for the non-lawyers among us, I would argue, as offensive, because that is not what we're about. Get up and make an opening statement or stay in bed. Right?
All right. Yes.
I'm Anna Cox, and we have a nonprofit, Compassion Works for All, and we do a lot of work in the prisons, working with a lot of individuals, and seeing still the enormous amount of racial prejudice and prejudice against people of poverty, and how limited their support, legal support has been. I appreciate so much your passion and caring about these people. We put a lot of our time and effort and energy into trying to educate the public and speak with officials and lawyers, and to meet with a deaf ear is common. To meet with great resistance and hostility is also something we're up against all the time. What would you recommend that all of us who are face to face with these issues, trying to advocate for these people? I know we have innocent people on our death row, and how can we all work together to help change legal policy and just the mindset of people in Arkansas?
Well, look, the fact that you all showed up, I mean, I suppose there's some command performance aspect of this, right, that you're here, but you're here, and you're listening. And it was one of the reasons I wanted to talk about this aspect of these cases, which is, I think what we need to do, and I think that Innocence Work has done this to the good and to the bad, which is it has made people aware of and willing to talk about issues of crime and punishment and race and class, things that typically either make us uncomfortable or make us mad and brings out the demagogue in all of us. But I'd like to think that what we talked about today is a fairly sophisticated level of conversation. But though it's sophisticated, it's also resonant to us, no matter what your where you fall on the political line. I mean, these things matter to us as Americans. Not to be too patriotic, but they do. Fairness and justice, they matter. And I think to the extent that we can, when I say we, the royal we, all of us here, can leave here and try to raise the level of conversation. I know that sounds trite, but I think that's what makes the difference. You know, I say to my students, all of whom or many of whom will not be public defenders, that look, all I care about when you leave my class, I will be happy if a year or 5 or 10 years from now you're at a cocktail party and someone says, man, we ought to lock them up and throw away the key. If you just walk over and say, let me freshen your drink for you, okay, because we need to talk. I think that will advance the ball as much as anything else.
We need to ask Professor Carrington to come back over here and teach some classes over here. I think that'd be, I know that a lot of people still have questions, and I hope you'll talk with him following, but let's give a round of applause for Dr. Carrington. Thank you all for coming, and we'll see you next week, and feel free to visit with him after the program.